Welcome back to the program. It's the Vicki McKenna Show. So Lucas Weber, who is with the Wisconsin Institute for Law and Liberty, Wisconsin Institute for Law and Liberty has already indicated its intention to challenge the decision by the Wisconsin Supreme Court on the maps, assigning a non-neutral judicial panel to look at these maps. Lucas, welcome to the show. How many lawsuits are we talking about these existing congressional map lines since those maps were drawn?
Yeah, so this would be the third attempt. So there's two suits filed now, so I guess it's the third and fourth attempt here, but this will be the third time that somebody has challenged these maps, which were first adopted just a few years ago.
Okay, so what's the challenge this time? So they've survived every single challenge. The maps are fine. The maps are fine. What's the challenge this time?
Yeah, so the first one is just, once again, reviving the same failed attempt they've already tried, which was a partisan gerrymandering claim. So that's one of the claims. They're saying the congressional district maps are gerrymandered, partisan gerrymandered. The Wisconsin Supreme Court and the U.S. Supreme Court have both said those claims are non-justiciable and can't be brought. The other suit is trying something that nobody has ever heard of before, saying that it's an anti-competitive gerrymander, that somehow the Wisconsin Constitution guarantees competitive districts. And then they attempt to define that in a way, of course, that benefits their chosen candidate.
Okay, so we've got partisan gerrymander and anti-competitive gerrymander. And by the way, those things are the same thing. Those are the same exact things. So anti-competitive, does that mean that we get to draw a whole bunch of red capacity into Congressional District 2 so that there is competition in Madison and competition in Dane County? How about that? I've never heard of that in my life because I want red capacity and I want it also at the local level as well, but it doesn't ever seem to go that way.
Yeah, and nobody's ever heard of it, to be clear. I mean, this is a legal theory they made up out of thin air. It's never come up in any case ever that we could find. And the two, I guess you call them least competitive districts in the state would be the ones in Milwaukee and Dane County, which are both held by Democrats. So, you know, for these, I guess, Democrat sympathizers, I would say, the people who are pushing the Democrat agenda on the other side who are bringing these cases, to say that is rich in irony.
Okay, so that's what this, quote, neutral panel, and I just talked with Jessica McBride about this, that's what this neutral panel, which isn't really neutral, it's handpicked, hardcore, left-wing partisans of judges is going to do. They're going to look at these questions. So partisan gerrymander has been rejected. Anti-competitive is absurd because if anti-competitive is the measuring stick, then we need to have some Republicans winning District 2, okay? Period, full stop. My guess is they're going to try to find some way to manipulate language between those two concepts. But you can't do that. The Supreme Court has spoken on this, have they not, Lucas?
Yeah, so under the federal constitution, all of these claims are being brought under the state constitution. Now, that doesn't mean there aren't federal issues in this case, of course. And as we've been saying since they first started hinting at this, the U.S. Supreme Court has been very clear that state Supreme Courts, or state courts generally, if they're going to be involved in any kind of redistricting process, has to stay within what we'd call the ordinary bounds of judicial review. What they're trying to do here, just invent a brand new legal theory in the middle of a decade and then bring that case to the court to throw these maps out, is so far beyond what the U.S. Supreme Court had in mind that, you know, ultimately, whatever the Wisconsin courts decide in this, it's almost certainly to be brought before the U.S. Supreme Court.
Right. So they know that, but they know that. So how does this work then? Because this is my question. Is this, hey, let's do this, drag it out just long enough so that when Wisconsin Institute in Law and Liberty brings this case before the Supreme Court, there isn't enough time to do anything before the 2026 midterms? Or is it something that you can ask the Supreme Court to review immediately?
Yeah, it's the exact process going forward here is a little bit up in the air, just in terms, because a case like this has never been brought in Wisconsin. As far as I know, there's never been one of these three-judge panels utilized under the statute. But when the three-judge panel issues their decision, it would then be, the appeal would go directly to the state Supreme Court, and then any appeal from there would go to the U.S. Supreme Court. And yes, I imagine that the timeline of that would try to be expedited as quickly as possible. But,
okay. Yes, well, they're going to expedite only with enough time left where you're not going to be able to make the case. Because we know how the Wisconsin Supreme Court is going to rule, don't we? We already know. They've told us how they're going to rule. They did not select nonpartisan, neutral people to look at this. They selected hardcore partisans. In fact, one of them has already made the case to detonate these maps. So we know how the Wisconsin Supreme Court is already going to rule. And so it obviously has to get before the U.S. Supreme Court. And, my concern, of course, is they walk it to a time point where it's next to impossible to beat the clock in the 2026 elections. Right? I mean, Lucas, that's the big fear here. And I think that's why the Supreme Court originally, Wisconsin Supreme Court, didn't take it up as an original case. Why we're seeing this delay in electoral chaos going into 2026. Is there anything you can do to beat the clock?
Well, I think the kind of deadline, if there's one here, would be middle of April next year. I believe that's when nomination papers first begin circulation for the fall elections.
Right.
So, the three-judge panel, the way it would have to proceed here is the challenge first would have to declare that the current maps are unlawful, and then they would proceed to a remedial phase where they would attempt to draw new maps or change the lines. And then after that, it would go to the U.S. Supreme Court. So there certainly is, there's a lot of steps along the way. I don't know if it would even be possible to get that done. Would they want to get done and have everything to the remedial phase by April 15th, much less through the remedial phase? So it's going to be interesting to see how it all plays forward. And obviously we're going to be involved trying to uphold the rule of law as everybody's known it here in Wisconsin for decades.
So what they've been saying is that they're not fair maps. Of course, that's it, and we should explain what that means. That when you draw compact contiguous districts, which we do in Wisconsin, our maps don't look like Illinois. Our maps look compact and contiguous, meaning they look relatively, in terms of shape, they look like normal shapes. They collect people of a common interest. So you think Van Orden's district, common interest between, agriculture and manufacturing. They are of relatively balanced and equal populations versus what an honest to goodness political gerrymander looks like. That's Illinois, that's New Jersey, that's New York, that's California, that's some of these sort of infamous states. So the argument though is that, but Republicans win these seats. Dave Obey used to have that seat. Now he doesn't have the seat anymore. I think it's Tom Tiffany's seat, right? That a Republican shouldn't have that seat. In the case of Derek Van Orden, he shouldn't have that seat. So that's what they're arguing, is that it's not fair because Republicans are winning previously Democrat-held seats.
Exactly, and the other irony here is that there was a challenge to these to the maps after 2010 redistricting, on which these current maps were based. And they said in the court record on there, they made clear that the maps were drawn with input from both political parties. So, these maps have been looked at by courts for decades now, and have been upheld. And like I said, the very challenge that is already being brought, the partisan gerrymandering challenge, has been rejected. The other challenge is something novel that no one's ever heard of and has never been tried anywhere. So these are, some unique claims that are being brought up here, but the process will begin very soon.
The original maps were drawn with input from both Republicans and Democrats. That's what you're saying, because the legislature is supposed to be the body that does the maps. The legislature is supposed to be the body. And every single time we get to this, to the legislature, we used to say, whoever wins control of the legislature controls the maps, right? Not if you're on the left. But the Democrats did have a say. They already made challenges. Republicans did make adjustments based on input and challenges from the Democrats. It's just not good enough.
Exactly, and these challenges, continue to be brought here. Unfortunately, Wisconsin's kind of getting swept up in some of this national fervor on this stuff. But there's going to be, a lot of action in this case. It's going to be a lot of procedural issues and complex motions going forward, and it's one that we'll be happy to keep you in the loop on as it moves forward.
So everybody understands, the Democrats' old electoral strategy was collect everybody in the dense urban areas. That's how they were going to maximize power. And then once that no longer proved to be an effective strategy, once you started to see, voter enthusiasm and even population density increase outstate, so outside Milwaukee or outside Madison, all of a sudden, that excess voting capacity seemed wasted. And so we're up against Democrats not wanting to make a harder decision on electoral strategy, which is make a broad appeal message that can convince both Republicans and Democrats you're the candidate. And that's the way you win these seats, right? That's what Trump did in central Wisconsin.
Yeah. It's good. It represents a significant change in how things have been done here in the state, and it's unclear exactly how this would play out going forward too. I think in their anti-competitive districts claim, does that apply to state legislative districts then? If the Wisconsin Constitution guarantees you a competitive district, does that apply to your county level races? Do you do your circuit court races have to be competitive somehow? How do they even do that? I don't understand what the end game is here, but I think the fact that it's never been tried before.
If you're going to use anti-competitive, just to look at Dane County. Dane County used to be, maybe about a quarter to a third conservative to moderate Democrat, controlled by conservative to moderate Democrats. Way back in 2010, they obliterated the map. They got rid of the rest of the conservatives, and now I think there's one conservative on the Dane County board. Does that mean that we can go outside these areas of Dane County and we can pull people in so that we can have red balance again in this area? Because otherwise, how can you even make the anti-competitive claim without explicitly addressing Dane County, District 2, Congressional District 2? I think they could potentially open up an absolutely insane can of worms if these judges decide to come down on the side of this anti-competitive theory.
Exactly, and that's why the theory itself makes no sense practically or legally, and look forward to having its day in court.
Yeah, I don't. It's just chaos, and that's another part of the strategy. Lucas Weber, Wisconsin Institute for Law and Liberty, thanks very much for joining me.
Thanks for having me.